What is a fraudulent transfer in divorce? When a couple decides to separate, the division of assets can become a contentious issue. One term that often comes up in these discussions is fraudulent transfer. This refers to actions taken by one spouse to hide, move, or sell marital assets with the intent to prevent the other spouse from receiving their fair share during property division. Imagine one spouse selling a family home to a friend for a fraction of its value or transferring money to a relative just before filing for divorce. These actions are not just unethical, they can also be illegal. Such transfers can involve concealing assets or disposing of them altogether, which can significantly impact the outcome of the divorce proceedings. In the realm of elder law and estate planning, understanding fraudulent transfers is essential. These actions can undermine the equitable distribution of marital property and complicate estate planning. If assets are improperly shifted before or during divorce, it can affect trusts or inheritances, leading to disputes down the line. Spouses have a fiduciary duty to each other regarding marital property. This means they should act fairly and transparently. If one spouse transfers assets without the other's knowledge or consent, it can be presumed fraudulent. This is especially true if the transfer reduces the overall value of the marital estate unfairly. There are two main types of fraud in this context. Actual fraud involves a clear intent to deceive, while constructive fraud occurs when a transfer is unfair or lacks adequate consideration, even without explicit intent to defraud. If a spouse suspects fraudulent transfers, legal remedies are available. Courts can reverse these transfers, restore the marital estate to its proper value, and adjust property division accordingly. This could mean awarding monetary compensation or equitable relief to the aggrieved spouse. Timing plays a crucial role in these cases. Transfers made shortly before or during divorce proceedings are scrutinized closely. Evidence of concealment, lack of fair consideration, or transfers to family members can support claims of fraud. Many jurisdictions have laws like the Uniform Fraudulent Transfer Act that address these issues. These laws allow courts to void transfers that hinder a spouse's rights or creditor's claims. Additionally, transferring property can change its character, such as moving it from marital to separate property. Such transfers must comply with specific legal requirements to be valid and not considered fraudulent. From an estate planning and asset protection viewpoint, fraudulent transfers can complicate asset division and affect trust distributions or wills. Proper documentation and transparency are vital to avoid disputes or claims of fraud. In the context of elder law and estate planning, fraudulent transfers during divorce can jeopardize long-term asset protection strategies. This includes offshore trusts or other estate planning tools, which may expose assets to legal challenges or force redistribution contrary to original planning intentions. Seeking careful legal guidance is essential when dealing with asset transfers in divorce to ensure compliance with fiduciary duties and avoid allegations of fraud.